Wonderful. Welcome, everyone. Thank you so much for joining us for this really unique and special webinar in partnership with the Bateman Horne Center as part of our ongoing series on severe ME/CFS, care, rights, and research. This is I believe, our second in the series, or our third in the series. Specifically, we're looking today at legal planning for severe ME/CFS, steps to take that you might need in managing health and life decisions as you navigate a severe disability with ME/CFS. I am just really excited to bring this panel to you all. By the way, my name is Emily Taylor. I'm the president and CEO of Solve ME, and I have journeyed through many of these issues with my own family. The reason why I'm particularly excited to bring this webinar to our community is because I learned a lot of these things very early on in my mother's journey with ME/CFS, actually through my work in autism. When my mother was about 3 or 4 years into her illness, we had an amazing caregiver join our family. Love you, Jonah, wherever you are. Hope you're watching. Then this caregiver enabled me to go back to work, and I worked at an autism organization. And as part of my work at the autism organization, I was instructed on a lot of these elements regarding SSI, SSDI, conservatorship, and guardianship. And I learned about these things in order to help others. And I was shocked when I learned these pieces of information that were so helpful to those in the autism community. And I realized that in my ME/CFS journey with my family, I never had access to this information. This was not something that was particularly emphasized. So I'm very excited to bring this piece of information with our amazing panelists to the ME/CFS community. And I hope that those of you who are struggling with severe ME/CFS or loved ones with severe ME/CFS have some nuggets and tidbits that are helpful from this webinar that help you navigate your lives. Based on the feedback of the community, we're going to be talking about two items specifically today: the topics of disability insurance and guardianship, advanced directives, and power of attorney. To that end, we have some amazing panelists joining me today. I am so grateful for their time. First up, we have Barbara Comerford, who will be speaking on Social Security disability insurance and supplemental security income and all of the nuances in that space. And then secondly, we'll have Mike Gilfix, who will be speaking a little bit further about conservatorship and guardianship. And to that end, I'd like to introduce them with a little bit more depth. First speaking is Barbara Comerford, who is a practicing disability law in New Jersey for over 30 years in the primary area of ERISA long-term disability insurance, claims for litigation, Social Security disability claims and litigation, and she's represented thousands of clients and specifically some landmark cases with ME/CFS. I am so lucky to have worked with Barbara in the past, but I'd also like to highlight that Barbara is the author of some of the amazing resources you'll find on the Bateman Horne website as well, and you'll see some of her information in the resource guide that will follow this series. So I just wanted to welcome Barbara and thank her so much for joining us. And then quickly, before Barbara gets started, I will introduce Michael Gilfix. Michael is a nationally known authority in the field of law, aging, and estate planning. Originally from Stanford Law School, he's a fellow of the National Academy of Elder Law Attorneys and a co-founder of that same organization. Certified legal specialist in estate planning, trust, and probate law, Mr. Gilfix is an amazing California legal advisor who's worked on many cases relating to disability and long-term planning. What I love about Mr. Gilfix and what he brings is he really uses the law to make space for families to not use the law. It's the perception of how can we protect you without having to take away some of your rights and responsibilities. And so with that, Michael will share that perspective in his presentation. Again, I'm just so excited to bring this information to the community. And last, before we get started, I just want to share that this is specifically about the legal side of the equation. A lot of folks have submitted questions and thoughts about accessing services through your legal programs. That was a separate area of law that we hopefully will cover in a future webinar, but we really are zeroing in on the legal protections and the boundaries around the law in these areas in this panel. So for those of you who have questions about accessing, we might get a social worker, some other folks to talk about that in the future. But for now, we're talking about those legal guidelines around these areas. So with that, enough from me. I'm so excited to turn it over to Barbara to hear her thoughts about SSDI, SSI, and all of those pieces. Barbara, take it away.
Thank you, Emily, for that wonderful introduction. And I wish I had been in touch with Mike months ago because I needed his expertise and my family has been caught up in guardian hell. So Mike, you're doing God's work, Anyway, I am here today to, first of all, thank all of you who are caregivers for people with ME/CFS, because it is a tough road to hoe, because unlike a lot of illnesses, ME/CFS still does not get the recognition as an illness, as a debilitating illness that it deserves. And it makes me sick to know that for many, many decades, I have been trying to, along with many other people, trying to get the world to say that this is a legitimate illness. But unfortunately, we still have that kind of issue to deal with. And one of the things that I wanted to share is that in the late 80s, early 90s, I was really devastated and debilitated with ME/CFS myself, which is what led me to this journey, because I was a litigator. I was someone who was extremely active and busy as a mom to young children. And I had a number of responsibilities, and my life came to a screeching halt. And I was very fortunate at that time to have a treating physician who had read the Annals of Internal Medicine article about what was then called chronic fatigue syndrome. And he said to me, and I said, just give me the pills, give me whatever I need to feel better. And he said, Barb, there's really nothing but rest and maybe Zovirax for the shingles that you've developed. So it was pretty devastating for a young mother, a young attorney just starting her career, to have been felled with this. So, and I now have a daughter who is a college professor who struggles with it. And frankly, I have several members of my family who struggle with it. So I am here to say, I hear you, I understand how devastating this is, and I really, Emily, you are to be congratulated, as are all the caregivers who are here today. I'm going to be talking a bit more about, I'll not only be dealing with the Social Security disability issues, but I also would like to touch on ERISA, long-term disability insurance, and disability insurance policies, which a number of people have. And when they get sick, they think that the promise of those policies will be there for them. But unfortunately, I exist because, and the work I do, and my associates do, and my paralegals do, we exist because that promise is often breached on the part of insurance companies and employers. I said it earlier to Emily that I would be more than willing to answer any questions anyone has. I do it every day. People call me because we have cases all over the United States. So I answer questions when people call and say, I don't know what to do with this. What do you recommend? I have no problem giving a free consultation to people. So I just want to make that clear too. If you can't get somebody in your area who understands ME/CFS and the law in this area, you really need to touch base with someone who does. And I am willing to play that role. Whether you retain my office or not, I am perfectly willing to give you guidance, because it is a very upsetting experience. One of the things I would like to discuss is that ME/CFS used to be known as chronic fatigue syndrome, and that name wreaked havoc in the 80s and 90s after the Annals of Internal Medicine argument. And believe me, the researchers who put that definition together, they did it mostly as a research criteria. They didn't do it so that if someone walked into a doctor's office like I did with my doctor and say, I'm feeling this, this, and this, what do you think? Many of us back then satisfied that tough, rigorous CDC research criteria. And despite satisfying all that, we were often left empty-handed when we went for things like disability benefits, or when we went to doctors, they just didn't understand the illness. And my argument back then was always the research and the dollars for research will only solve this problem, because until the research catches up with the illness itself, we are going to be left in this no man's land. I'm here to tell you that that has changed, and that's really good. And the Bateman group, I mean, they do fabulous work. I mean, Cindy Bateman was wonderful, but they do fabulous work in terms of medically documenting a lot of the symptoms that people with ME/CFS have. And I would like to just quickly talk about the kinds of things that you have to document in a disability claim when you have ME/CFS. Those of you who are caretakers and those of you who have ME/CFS also completely understand that there are certain things you see all the time. You will see brain fog. You will see cognitive deficits that you've never had. A lot of people with ME/CFS were really, really sharp when they were in the workforce. They could multitask and do 50 million things. Suddenly now, just watching a television show can leave them feeling confused and exhausted. Or reading a book, which may have been nothing for them before, they have to reread it all the time just to try to grasp what's going on. Many people with ME/CFS who call me will say, I watch television and I'll watch a movie, and my family gets annoyed with me because I'll keep asking what happened, and they'll be like, you were sitting right here, stop interrupting us so we can watch. So that sort of issue, that sort of cognitive issue, can wreak havoc in your life and in your ability to work and in your everyday ability to do activities of daily living. Another thing we are frequently seeing, particularly these days, is autonomic nervous system issues. Things like postural orthostatic tachycardia, which is basically when you shift position, if you go from a supine position laying down to standing up after 10 minutes, you suddenly start feeling lightheaded and dizzy and weak. Like neuropsych testing for cognitive issues, which I just addressed, they have to be medically documented in the context of either Social Security or in the context of dealing with an insurance company. I'm sorry, I have a little cold. Dealing with an insurance company in the context of a disability claim. So if we're looking at either one of those things, if we're looking at dealing with the government and Social Security, or if we're talking about a private disability pension, what happens is we have to be willing, we have to know that we have to invest in getting medically objective evidence to support these claims, or frankly, you're doomed before you start. So one of the things I strongly recommend people with ME/CFS do for any of these claims is get cardiopulmonary exercise testing. That is a very crucial test. It's a traditional, standard, medically recognized diagnostic for a very long time, and it's been used in the last couple of decades to document post-exertional malaise in chronic fatigue syndrome and myalgic encephalomyelitis cases. Now, you who are sick with ME/CFS know that you have these false starts. All of a sudden you wake up and you're having a good day, because there are good days and bad days with this illness. How do you document good days and bad days? One of the things I say is keep a journal. Why do you want to keep a journal? Because if you keep that journal, you can turn it over to your treating physician, and please, I'm begging you, only see treating doctors who recognize and who understand myalgic encephalomyelitis, chronic fatigue syndrome. Because if you go to a physician who's unfamiliar with it or doesn't believe in it, you will be gaslit like crazy, and it will do nothing to advance your case with either the Social Security Administration or with the insurance companies. Having a doctor who knows this illness, understands what you need to do to medically document it, without that, you don't have a case. And I will tell you that repeatedly. So, and the same is true with getting neuropsych testing for cognitive deficits. There are plenty of neuropsychologists throughout the United States. There are not very many who totally understand the specific types of deficits you will see in ME/CFS cases. What are those sorts of deficits? You will have speed of processing problems. You will have working memory problems. You will have problems basically, and what this means simply is, oftentimes you have a situation where someone was a great multitasker in their job. They handle 50 million things, probably the way Emily is. You know, she's dealing with 50 million things a day. If tomorrow she started experiencing cognitive deficits, she would start saying, oh my God, what was that meeting about? What was I supposed to be doing today? And no matter how many prompts or reminders, you still feel overwhelmed. That's what many people with ME/CFS experience. And as a result of that, many of them are professionals and can't even think about continuing in their position because they are so impaired cognitively. So the first thing you have to do is look for a neuropsychologist who understands ME/CFS and the deficits that present, because a lot of neuropsychology reports that I get from people who don't do that, they test them for they just run the same tests over and over again without acknowledging the various domains that are very prominent in these cases. So the case that some of you may be familiar with, Vastag v. Prudential, was we represented the science writer for the Washington Post who was denied repeatedly in an ERISA disability plan that the Post had taken for their employees. And he actually covered the NIH and the CDC. And frankly, he was highly critical of them for the way they dealt with ME/CFS for years. And then he got it himself. And fortunately, he did take the steps to document objectively his deficits. He had CPET testing, he had neuropsych testing, and he had some other tests that are not commonly seen, but were helpful. And we were really fortunate because we were in front of a federal judge in New Jersey Federal District Court who was very well regarded and who knew the questions to ask, and we were happy to deliver the answers to her. And basically what she said in her decision is that Prudential was unfamiliar with this condition and what constituted objective documentation, and there was plenty of it in this case. So I can't emphasize enough how important it is to invest in these tests whenever you're going through the process of filing for these disability claims. I say to people, look, years ago, I had my brother who's now deceased, who was a vitreous retinal surgeon, said when he was helping a family member of ours out and they needed $50,000. And he said, if you had an inoperable brain tumor, but that they were willing to do the surgery for $50,000, do they think I wouldn't have given them that? And that's really the linchpin in this situation. You need to invest in the tests that document your illness in order to reap the results of that. So those are some of the things. My PowerPoint goes into a lot of detail, breaking down these specific tests and how they're done and what constitutes objective medical evidence. The other thing is that you also want to know that in every Social Security case, every single one, they go through what's called the 5-step sequential evaluation process. And that sounds like a bunch of rigmarole. But the truth of the matter is every single Social Security case goes through those 5 steps. One of the first 5 steps is whether or not you are engaged in substantial gainful activity. Substantial gainful activity means, and there are all kinds of Code of Federal Regulation provisions on it and case law on it. But essentially, one, is the person working? If they're working and it's in a competitive work environment, they are denied at step 1. Because for all but one step, you have to answer yes, that you satisfy the test, or the test stops and you can't pursue the disability claim. So if someone is working in a competitive work environment, and they can no longer work in a competitive work environment, and they're saying it's as a result of their disability, they have to document that they are not earning income in a competitive work environment as a result of their disability. And by the way, it's a presumption. It's a presumption that can be rebutted. So if someone is working, let's say for their Uncle Toots, and Uncle Toots pays them $5,000 a month just because he loves his nephew, and the nephew comes and says, oh, I'm working and I'm making $5,000 a month, which is well over the substantial gainful activity amount for non-blind individuals. I think it's like $1,600 and change per month. Ordinarily, people would say, well, you can't qualify because you exceed the substantial gainful activity amount. The truth of the matter is that it's a rebuttable presumption. So when we come in as your attorneys and say, yeah, but that's because Uncle Toots loves him, he wouldn't do it for anybody else. It's what we call sheltered employment. And as a result of that, he would satisfy the SGA requirements because you've rebutted it with evidence documenting why it shouldn't be acknowledged. At step 2, so then you can proceed to step 2. At step 2, the question becomes, does the person have a medically documented impairment that has lasted or is expected to last for 12 continuous months? And is it as a result of this disability that's been objectively documented? If you can produce things like CPET testing, neuropsych testing, and the NASALEAN test results, and tie it into your inability to perform basic work-related activities, sitting, standing, reaching, reading, remembering, concentrating, dealing with other people. If the answer to the question is yes, we have medically documented this objectively, we have shown that there's a causal connection between those limitations and the disability, and it has prevented this person from working for at least 12 continuous months, or it's expected to do that for the next 12 months, or it results in death. And by the way, I have had ME/CFS clients who have died as a result of blood clotting issues, which is still going on. The problem is if you've answered yes to those questions, that person is satisfied that standard, you then go on to the third step in the process. At step 3, the question becomes, does this person suffer from an impairment that meets or equals a listed impairment? What that means is Social Security has a list that consists of 14 different bodily systems, and in that list are a number of disabling impairments. There is not one for ME/CFS at this time, and there has not been one. Social Security has passed what we call rulings to give some guidance to judges and lawyers on how these claims are to be assessed, but there is not an impairment listing saying, okay, if you can show with neuropsych testing, if you can show with NASALEAN test, if you can show with CPET testing that this person objectively documents that, then you've satisfied the impairment listing. There isn't one, so we can't do that. So what I generally tell my associates is, look, and when I teach it to lawyers, I say, honestly, I wouldn't waste too much time on a step 3 analysis because there isn't an impairment listing for ME/CFS. So fortunately, it's the only step in the 5-step sequential evaluation process that you don't have to satisfy, and then you can go to step 4. At step 4, the question becomes, and historically the question was, can this person, as a result of their residual functional capacity, which means after the illness gets through with you, what do you have left in terms of functional abilities? What happens is we used to have to get a very long history from people, what they did in a work setting for the last 15 years, because that's what the Code of Federal Regulations required, that we had established they couldn't perform their past relevant work for the last 15 years. Fortunately, in June of this year, a code provision was passed, which says we only have to go back 5 years, which is more reasonable. Most people have all kinds of work experience, but to go through each title they had, what they had to do in that job, and eliminate every single work activity they had to do in that job was really onerous. And so fortunately, they changed the code, so we only have to go back 5 years. So you have to be prepared to look at what you did for the last 5 years before you became disabled, and then establish what it was now that prevents you from performing that work after that 5-year period. And once you can do that, then you can move to the last step in the sequential evaluation process. And at that last step, at step 5, the burden is placed on Social Security to document that there are jobs in the national economy that this person can perform in light of their age, education, and work experience. Toward that end, Social Security has what we call a medical vocational guideline grid. And basically, you look at one side of the chart and you say, okay, is this person a younger individual? Does this person have transferable skills? Is this person highly educated? And by the way, in the context of Social Security, a younger individual is someone who is under the age 40 and under. A person is highly educated if they graduated from high school. A person has transferable skills in just about every area, and whether or not that person is able to use the skills, education, work experience, and their age as a positive vocational factor. In the case of MECFS, as many of you know, we have a lot of young people who suffer from this, which is usually the kiss of death in a case where you're applying the medical vocational guidelines, because the younger a person is, the more highly educated they are, the more transferable skills they have, they are likely to look on the far end of that grid and see the words not disabled. So what do we do in MECFS cases? We tell judges, look, those medical vocational guidelines are only to be used when you have someone who suffers simply from deficits in strength. In MECFS cases, because we're implicating their cognitive status, we're implicating their ability to do anything and not crash, because that's what post-exertional malaise is, which is what CPET documents. When you've got somebody who can't predictably say to an employer, I can report to work 5 days a week, 9 to 5, and you got me. People with MECFS know that on their bad days, they're lucky if they can shower. They're lucky if they can get out of bed. They're lucky if they can do minor physical exertion. And on those days, often what preceded that was somebody waking up and feeling good and saying, oh God, this is wonderful. I'm on I'm on the last leg of this illness. I can do all this stuff. Unfortunately for MECFS people, that's usually the ones with the severest cases. That's usually very short-lived. So as a result of that, when you have someone who is looking at a grid analysis, that medical vocational guideline analysis, what my attorneys do and what I did historically was say, look, this is not a case for the grids. This is not a case for the medical vocational guidelines, because while my client is young, highly educated with lots of transferable skills, they don't know if they can get out of bed on a given day. They don't know if they get out of bed, whether or not they can shower. They don't know if they can shower, whether that and getting out of bed is going to knock them out so much they're gone for that day and maybe many more days. So all of this becomes critically important in understanding where you are by keeping a journal all the time, because sometimes people don't even remember. I'll be interviewing somebody and they'll have a spouse say, no, you do that. You couldn't do that. I had to do that because you couldn't do it, because people in this context generally lie against themselves because they want to remember themselves in their pre-disability life. And unfortunately, in this context, a very dear friend of mine who's a federal judge was saying to one of my clients one day, look, this is the place you come to complain. This is not the place you come and to pretend to be better than you are. So the only way I know whether or not you're deserving of this is you have to share with me what your life experience is. And I encourage all of you, become comfortable with listening to people who are providing care for you, who often have a much better insight into how impaired you are. This is what you need to do. It takes a village, so you need support in terms of testing that you need. You may have to borrow funds from some family members. You may have to do all those things, but it's an investment in your future, because not only is Social Security disability, they will check and they will ask you from time to time after you've been awarded benefits to fill out forms to document that you are still as ill as you were when they awarded benefits. But you're also going to realize that this is a lifetime benefit. So unless you improve, it's going to be there for you for life. And the only difference between supplemental security income benefits and Social Security disability income benefits, Social Security disability income benefits, which I discuss in the PowerPoint, requires most people to work 5 out of the last 10 years and contribute quarterly to your Social Security trust fund taxes, because once you do that, you've satisfied the basic requirements to tap into that system. Supplemental security income benefits has the exact same medical requirements, but they do not have the contribution requirements that Social Security disability has financially. So if you're someone who's never been able to work, let's say you've been sick all your life, or there are plenty of people who were the spouse who took care of the children, they never worked, they didn't have this, and then if a spouse divorces them and they're left high and dry, obviously they have to meet a financial requirement to show that their income falls below poverty levels and that they need these benefits to survive, and that medically they've established that. So, and by the way, I didn't talk about the ERISA and the disability insurance claims, because quite frankly, it's a lot to cover. But I do give you a tremendous amount of detail in my PowerPoint. And again, I am telling you, for those of you, for both Social Security disability and for disability insurance claims, the paramount thing to keep in mind is medical documentation, objective medical documentation. And because of people like Cindy Bateman and a lot of other wonderful people who suffered through documenting this illness for years, we now have things that I've discussed earlier, the CPET, the neuropsych testing and things of that nature. But that's the most crucial thing. If you walk away with nothing else today, you must make sure that you medically document your limitations and give your notes, your journal notes, your daily journal notes to your physician, so that when they get forms from Social Security or from an insurance company, they have the ability to answer those questions.
Thank you, Barbara. That was so helpful. I really appreciate that insight into the perspectives and the mechanisms used by judges and lawyers when they look at this. It's so different than what we ourselves think about as health and wellness. And so it's just that different mindset. Thank you for giving us a spotlight to kind of understand some of that. The one thing I just wanted to add, and thank you again, Barbara, is the CPET at CPET, that stands for cardiopulmonary exercise testing. Exactly. And sometimes it's invasive cardiopulmonary exercise testing, which is an ICPET. For those of you who are looking into these particular tests, as Barbara said, they are the gold standard in disability cases, but I just want to offer a word of caution that these tests, as helpful as they are for documenting your disability, do trigger or can potentially trigger PEM. They are exercise testing, and what they do is they actually measure in your metabolic and breathing and cardiovascular function PEM in real time. That's why they're so valuable for documenting disability, but they can be dangerous if it's somebody who's so severe that the test itself will trigger PEM. So that's something you might want to weigh, discuss with your doctors and your attorneys about, is the test needed, and will that potentially cause harm to your well-being, or is that harm worth it because you need your Social Security or your disability? So it's a tough decision. I just want to put up that flag for those who are considering that testing. If anyone wants to learn more about CPET or invasive CPET testing, they're in the slides. I definitely recommend the slides, which will be available after this webinar. And additionally, the Workwell Foundation, has a great webpage that describes the test if you want to see it more in detail, and we can add that into the PowerPoint and the resources afterwards as well. So again, thank you, Barbara. That was so helpful. I am just floored by you managed to cram so much information in such a short amount of time. But with that, we'll turn it over to Mike to talk about the flip side of the disability landscape when it comes to guardianship, conservatorship, and those challenges in the legal framework of caring for somebody who's disabled. Mike, thank you so much for your patience. I turn it over to you.
Sure, thank you much. First thing to say, I've heard many presentations by attorneys and others on the issues that Barbara addressed, and she's excellent. I'll just tell you, honestly, I don't really know Barbara. I just met her today. Barbara's a heck of a resource, so I personally very appreciate it. To get those points organized like that and go through them so everybody could understand, that's rare. So again, thank you. Two other quick introductory points. Some of the concerns that I've seen in the Q&A go to whether certain benefits are going to be available into the future. So as an apolitical statement, truly an apolitical statement, the new administration has said they're going to keep Social Security and Medicare intact. Medicaid, which is critical to so many folks around the country who have these health issues, we are a little bit concerned about that. They're going to be potentially cutting the budget for that, and the criteria could be stricter. So it's sort of an advocacy point for the organizations to watch out for, and as individuals to be in touch with maybe members of Congress as you see some of these issues evolve. As we talk about these issues, guardianship, conservatorship, what we're really talking about is control. What if somebody gets to the point where they're not really able to manage their own affairs? What do you do? Is there a need for what's called a guardianship or conservatorship? Guardianship is generally the term that's applied when someone goes to court and they say that mom, dad, my sister, my spouse is not able to make decisions. I need a court order to let me do that for that person. In California, we call it a conservatorship. Guardianship is for minor kids. Doesn't matter. It's a court-managed process where, again, someone is appointed, typically a family member, not always, it's one of the many issues, necessary if the individual hasn't done basic planning. And we're going to go through the basic documents that I'm sure everybody on this call, I'm sure you've all signed the documents I'm about to mention because they're so fundamental. Once you're 18 years of age or older, you should do the power of attorney, the advance directive. So I'm sure that everybody on the call has already taken care of this. Okay, we'll go on. So the conservatorship, again, is necessary if you haven't planned. Because if you've taken the appropriate steps, there should never be a need for going to court. Court is a last resort. We work overtime to keep people out of court, away from guardianships, away from conservatorships. Okay, let's go on. Okay, so what does conservatorship even mean? In most states, using one term or another, there's the conservatorship of the person, which is appropriate when the individual is not able to make appropriate decisions about healthcare, where to live, the personal issues of life. The conservatorship of the estate is when an individual can't manage their money. They just can't pay their bills. They can't deal with decisions about investments. They just need that kind of help. Unavoidable sometimes. The first PowerPoint goes to this issue if somebody is a danger to herself or others. This is the extreme. This is not the kind of conservatorship or guardianship you would be dealing with. This is someone who's schizophrenic, bipolar. Just to say, though, there's a whole other level of conservatorship or guardianship where a court can authorize someone to hospitalize an individual, authorize psychotropic drugs, not your situation. So again, the point is to avoid all of this by proper planning. So let's go now to the documents that you should do, that you should have in place. With most disabilities, individuals who are diagnosed can still sign documents. The bar, in my judgment, is relatively low if you're going to name a family member in a power of attorney and an advance directive and giving them power in your trust. So what do you do about asset management? There's 2 documents everybody should have if you have any assets at all: a revocable trust. And without all the details, in this context, the point is that you create your own trust. You're the trustee. You manage everything. And you will say in the trust who will take over and manage your assets and your affairs, your trust assets, if you can't do it. You choose the person who is most responsible in your life, not the person you love the most necessarily, somebody who is highly, highly responsible. So again, there's a lot to say about trust, not today. Durable power of attorney, probably most important, because whether or not you have assets, you need to do that. Here you're basically saying, if I can't manage my daily financial issues, sign a contract, whatever it may be, I'm authorizing the person of my choice to be able to sign my documents on behalf of me. And a real caveat here, I'll just say, watch out for AI. AI is going to do some great things in the world of law. There's no question about that. But the temptation for so many is to go online, find documents, AI will create them for you. And when you have medical issues and a durable power of attorney, there needs to be language, among other things, stating that, for example, if I become incapacitated, or if I acquire assets, and those assets, the way I hold my assets, if that could interfere with eligibility for SSI, not for SSDI, Social Security Disability, but for SSI, there's asset caps. So a power of attorney can authorize the person named to make changes, to reorganize assets. It's remarkable what can be done proactively to achieve eligibility on the issue of assets. Barbara did an extraordinary job on dealing with the really hard issues, but here we're talking about, what are the criteria that have to be satisfied? How many assets can you hold in your own name? What trust should you create, etc. So the power of attorney can authorize all of those steps. Okay, healthcare decision making, needless to say, critically important. We in California call it the Advanced Healthcare Directive. The Advanced Directive. There's a corollary, there's a document like that in every state in the country. The post form is end of life, which is important, but for our purposes, frankly, secondary. Okay, so let's go on. Everybody see what? Okay, so the Advanced Directive. It should not be a simple form. There are many forms online. Some are better than others. Ideally, if you can, you would talk with someone who understands these documents, knows the issues to address. And again, when someone does have a disability, and in our special needs work, our current list is we are up to 48 different diagnoses that we've worked with over the years. And sometimes the Advanced Directive takes into account the particular issue that the individual, that the client needs to address, their concerns, their special needs, et cetera, et cetera. Okay, so with the Advanced Directive, you're identifying the person who can make healthcare decisions for you on your behalf. The most important point is they should not use their judgment to make decisions about your medical treatment, because there could be a need for that time and again. Their responsibility is to understand your wishes, how you want things done. And your Advanced Directive should be as explicit as you can possibly make it, so they know what you want done. If at some point they're not able to communicate, they can't communicate their own decisions to the physicians or the medical team, and they can't communicate those decisions to other family members. So the third point is most important. When you have somebody named in the Advanced Directive, they need to take care of you. They need to be a patient advocate. And that means not just passively making decisions when things come up. They have to take care of you if you're in a medical setting. Those of us who have a lot of experience, and I've been on some ethics committees at hospitals, and my wife, who's an attorney here, she was a patient advocate at Stanford Hospital. These issues are everywhere, and you know that more than I. Hospitals are dangerous places. So the person in your Advanced Directive, again, has to be an advocate, not just somebody who pops up when there's end of life decisions. So that's the Advanced Healthcare Directive that everybody age 18 and over should sign. If you haven't done this yet, you should do it like that. That's your next action step. It's not that complicated, absolutely essential document. Okay, so that's the Advanced Healthcare Directive that everybody should do. We've talked a little bit about this. Some of the forms are not bad. There's the 5 steps. But again, some of them focus more on end-of-life decision-making than the kinds of issues that I think are of concern to so many people on the call. Because again, you can be very explicit about where do you want to live? What kind of care do you accept? Do you have unique religious or value-based issues? This comes up all the time. So again, individualizing the document, supplementing it with your own thoughts. I think that's enough on this slide because again, it's a fundamental document everybody should do. Now, back to the basic documents. One of our primary objectives for everybody is keeping people out of the court system. Rarely is that a good thing. There's some situations where an individual doesn't have trusted individuals, they're being taken advantage of, etc. Okay, the court supervision with a conservatorship or guardianship, of course that can be a good idea. But probably for every 10 clients who come to us saying they need a guardianship or conservatorship, if we end up getting 1 out of 10, I'd be surprised. Because we can usually find a sufficient level of capacity and understanding, notwithstanding physiological or even mental illness issues. Notwithstanding that, we can find enough capacity so the individual can sign the documents to stay out of court. And I mention court because if you only do a will, you don't do a trust, in most states, you're going to be in probate, which means the courts. With the probate, a judge appoints the executor, you nominate usually, but again, with the trust, you're deciding who's going to take care of you. You're deciding what the terms are going to be. And same with the power of attorney. When you sign a power of attorney, again, in every state, you have a couple of choices at the outset. Is the document going to be effective immediately? In other words, the person you name, they can already act for you. Or is it springing, which means there needs to be a finding by a physician that the individual is not capable of managing their affairs before the power of attorney becomes effective. In situations you face, I presumptively strongly recommend that it be the first, immediately effective. Why? Rarely is it a good idea to document a lack of capacity. We want to resurrect and reinforce capacity and decision-making authority, not undercut it. So if you ever need the power of attorney, and it's the springing, the kind that only goes into effect if you lose capacity, you have to document it. And that can be inconsistent with other planning steps that you might need to take. And again, incapacity for decision-making is a separate issue from your ability to work. All of the eligibility issues. Again, in most situations, it's a relatively low bar to find enough capacity to be able to sign these documents. Always watch out for simple forms, watch out for AI. And I realize there's fees involved in most situations, and I realize that's a deterrent, but you just got to make sure that your documents do everything that you need to do so that someone can take care of you, manage your affairs, and sometimes, very importantly, reorganize assets. There's some assets that are called exempt that don't interfere with eligibility for SSI. And there are other assets that can interfere. And some of the rules, honestly, they don't make sense. An exempt asset can be the residence, sometimes with a cap on the value, can be worth $500,000. But if you have $2,500 in the bank and no house, you're not eligible. I mean, the rules, they're not all consistent and entirely logical. But again, power of attorney documents can let someone else reorganize, take appropriate steps to achieve eligibility for government benefits. The living trust, power of attorney. Go on. The POLS form, as I mentioned, it's everywhere in the country. A very good thing about this form, and I think everybody should be aware of it, is that it's available everywhere in the country. It tends to be a pink form. You might have seen it. It deals with end-of-life issues. And what's reinforcing about it is it's a document that your physician also signs. The last point here is so important. It has to be consistent with the terms of your advanced healthcare directive. Those two should be done in conjunction with each other. I view the advanced directive, particularly folks with a diagnosis or dealing with your issues, the advanced directive is dramatically more important, again, because it's going to deal with healthcare decision-making while you're living. Where are you going to be? What kinds of procedures are allowed, are not? Who does what? And going to all of these difficult questions about finding the appropriate practitioner. If someone doesn't have the energy to seek out appropriate healthcare providers to do testing and to take care, well, again, it's going to be the person authorized in the advance directive. And they always, by the way, do have waivers of confidentiality. There are many protections for confidentiality in place in states and at the national level. And these documents need to be very clear in waiving those confidentiality protections so that the person named in the document can get all of the medical information that is needed. That's not a very complicated matter. It tends to be built in, but again, critically important. And as we go through these, you can go to the next slide. As we go through these, I just want to reinforce that the whole idea here is to reinforce individual decision-making, not erode it, but reinforce it so that every one of us can make as many decisions as possible for ourselves, that we're informed, that someone else is informed because someone assumes that we don't have the ability to make our own decisions. We want to reinforce the idea of capacity, of independence, of control, which I think affects our health, not just our assets and our management of affairs, but I think it affects our mental health, our physical health. We want to reinforce all of that. My last, I guess, overview comment will be that we view all of these issues from a multi-generational perspective. And one of the things I mean by that is that, and Barbara, I'm sure, has countless examples of situations like this. Somebody's diagnosed and their parents are not sufficiently aware of that, or they don't get proper advice, and they pass away and they leave a little bit of money, maybe a lot of money, to the individual, and that can destroy eligibility for SSI and Medicaid. So there is something called the special needs trust that is always appropriate if someone may, not necessarily will, but may become eligible for any of these government benefit programs. So again, simple summary, a special needs trust is something that parents would create for the kid or for a spouse or for a sibling. Any amount of money can go into a special needs trust, and not if it's properly drafted. And none of it counts. None of it interferes with eligibility for needs-based government programs. Yet, all that money is available to pay for anything that the beneficiary, that the individual needs for quality of life, for healthcare. An unfortunate fact is that so many physicians around the country, and especially in higher income areas like ours, they won't accept Medicaid. We call it Medi-Cal in California. They won't accept it because there's more paperwork and less money for them. So finding a practitioner can be a real challenge. If someone needs care and they can't find a physician who will accept Medicaid coverage or another government program, what are they going to do? Well, they need money. Maybe there was some money from mom and dad. Maybe it went into a special needs trust. Maybe it's from a sibling. Sometimes, by the way, kids create these trusts for their parents, putting some money into a safe harbor so that mom and dad will have some money available without interfering with eligibility. So, I don't want to get into sophisticated trust and tax planning, but these issues exist and they have to be considered as we put together a plan, again, to reinforce the independence and control of the individual, to use conservatorship and guardianship only as a last resort. It is there as a protection. It is there when necessary, but again, we want to avoid the courts whenever possible. All of us on the call, every single professionals, we who are so wise, we sometimes don't take care of ourselves. We need to. Everybody does. So again, your marching orders. Make sure you signed a power of attorney, an advanced healthcare directive. If you have any significant assets at all, create a trust. Make sure that you're organized and that you name individuals who are responsible, not necessarily the ones you love the most, not necessarily the oldest child, not necessarily the one who lives nearby, somebody responsible. And if you don't find somebody in your family, there are professionals who can serve as trustee and be named in these documents. So there's your overview of the planning approach that we take. Again, trying to reinforce the integrity of the individual, independence and control, and how we would typically go about it.
Fantastic. Thank you, Mike, so much. And I just want to reiterate that information. Again, what kind of attorney do folks need to speak to about these kind of trusts or documents to avoid ending up in the courts? What kind of attorney should folks look for?
Yeah, there are many attorneys who specialize in the world of special needs. And there's my bio showed there's one called the National Academy of Elder Law Attorneys. most members, frankly, you pay your money and you're joined. Just because you're in that academy doesn't mean you know what you're doing, but most do. So the National Academy of Elder Law Attorneys, for something called the Special Needs Alliance. There are many resources available around the country. Do be careful, check out background. A lot of attorneys like this area because if we have a social work bone in our body, we like doing this kind of work. So, be careful about who you choose, check out the background, check out credentials. But again, there's a lot of attorneys around who can help with this.
Fantastic. Thank you so much. We're going to segment to do our Q&A section now. We've had so many questions come in. We have over 50 questions submitted. So I apologize that we're not going to get to everybody's questions, but I will do my best to try to consolidate all the questions into a couple key areas while we have time. The first area I'd like to touch on, we've got a lot of questions about that cardiopulmonary exercise testing or invasive cardiopulmonary exercise testing, that CPET area. And the main question is around what happens to people who are so severe that a CPET is not an option. If they have that moment with their lawyers and their doctors and they say, you know what, the risks of this test outweigh the benefits. Are there any alternatives or other mechanisms that you all would recommend for folks who are that severe that a CPET is not an option?
Well, if that question is directed to me, and Mike, thank you. I learned a lot from your presentation. Thanks a lot. But if it was directed at me, I will tell you that, frankly, one of the things that we used to do in the old days, which is before all these tests came up, one of the things that we used to do is basically look for the clinical complaints that people made. So when you are going to your doctor, and now a lot of it can be done via telehealth, if you are going to the doctor, and that's why the keeping a record, keeping a journal of your complaints and how debilitated you are, plus also, quite frankly, having the doctor create a document that says this person is so impaired and so ill, I do not recommend this testing. In fact, to be honest, years ago, when they used traditional functional capacity evaluations from my CFS clients, I routinely, because those were horrible for people to go through. And quite frankly, they were so biased in favor of the insurance industry or the government that what they did was they would hire people who would administer these functional capacity tests, which frankly, I don't even know how they exist because they're not even really well peer reviewed. What they would do is halfway through the first portion of the test, my CFS clients would say, I can't do it. I'm going to faint. I'm sick, particularly if they had a lot of autonomic issues. And what happened was they were just, the person administering the test would say, self-limiting behavior. This person isn't ill. This is just self-limiting behavior. They're trying to rig the test. So I wrote with Richard Podell, who was a fabulous CFS physician years ago. Richard and I wrote an article on why FCE testing was deleterious to people who have ME/CFS for a whole host of reasons. So back then I would say to the doctors treating my client, I need you to document that this FCE would make them sicker. And the same could be used in a CPET testing situation. You just need a doctor to explain this person is too sick. They're so sick they can't even undergo the objective testing that would document their case. But I would recommend in those cases, if that's too difficult for them, particularly if it's an invasive CPET, if that's too difficult for them, that they at least look into the neuropsych testing if they have cognitive deficits, and they need to have the autonomic nervous system issues if they suffer from that as well, documented clinically, because those are objective manifestations of their symptoms.
Great answer. And then actually one of our respondents mentioned a QEEG test.
Yep.
Is it alternative?
Yep.
Is that a good option?
Yeah, that is. And Brian Vastag had the QEEG testing done. I didn't want to get into QEEG because I'm not I don't see it as often as I see the other tests, but yes, that was very impressive to Judge Hayden in that case.
Fantastic. Some really helpful advice there. I hate to change topic, but there's so many other questions to get to. One of the interesting questions that came through was dealing with poor medical documentation. And we just heard how important on both sides of the equation medical documentation is. But what if you have, for example, a bad actor in your medical field in the past who's left some bad notes in your chart? What are your rights when it comes to editing the notes or changing the notes or disputing the notes? How can you go about, if in your medical history, sort of cleansing the bad actors from your history there?
I don't know, Mike, if you want to answer. I mean, I have an answer for this because particularly I'm doing a lot of long COVID work now too. You would be shocked that the long COVID clinics, which are supposed to be there for expertise, undermine completely those long COVID cases by putting things in there like psych case with nothing that the patient said to them indicating they had a psychiatric history, but because of the person, and often it's young doctors without a lot of experience, and they're just, their own bias comes in, and I see psych cases all the time. What I tell my clients to do, and because usually they don't even look in the portal, I'm the one looking at the portal, or Adam, my paralegal, is looking at the portal, and we're the ones who find these things. What I say to them is, you can't remove it. That's not what, you can't do that. What you can do is contact the physician, and sometimes they're superiors, sometimes they're managers, and say, this was incorrect. I never told you that I had a history of psychiatric impairment. I want you to correct that in my chart. And that's perfectly acceptable because what they wrote isn't true. And it's, and short of saying to them, I'm going to bring you up on ethical actions, short of doing that, that's about the only way you can really remedy it.
Oof. And Mike, if you have anything to add to this one. So similarly, in the same vein, what about folks who are too impaired to physically sign a document on their own? What sort of protections, or can a power attorney be used at that point? How can you help folks who are so physically impaired, but still mentally, able to make their own decisions, but physically incapacitated from executing those decisions? What space is that a power of attorney? And how would you recommend? Is there digital signature options? How would you recommend navigating that space, both in the medical space where you need to sign documents for medical purposes and in the legal space?
Okay, so digital signing is happening in some states, not all. It's coming along. It's going to be more prevalent. Also, there's the ability, and notaries know all about this. And if an individual is physically unable to sign, they can direct another person to sign for them. There's some special witnessing requirements typically if you're going to do it that way. So there are solutions in every state. And I want to add, we have 30 webinars on our channel. So if you could put that back on the screen where people can just sort of zap it and sign, it's a free thing. We have countless webinars on all of the topics that we've been addressing. Yeah, there you go. On special needs trust, when you need irrevocable trust, on powers of attorney, on and on and on. So it's free. Sign up for it. We're constantly updating it. We're doing a seminar tomorrow on the impact of the election on some of these issues. So once we do the seminar, we're gonna do a webinar that will also be available. It's a resource for everybody to know about.
Fantastic. And now my very last question, because I know we're almost out of time. This comes from folks who were successful in achieving either SSDI, ERISA, or another form of Social Security support, and then subsequently it was revoked from them due to quote unquote improvement or disargumentation, but it was an inappropriate revoking of that service or of that right. How would you all recommend going around if you had those things, but then they were taken from you? How do you fight back and get them back? And I know that's a long question, a big question to end on, but for folks who are in that situation, how would you recommend navigating that? Is it like starting fresh from the beginning, or is there a different pathway if you're in that situation?
For SS cases, what you do is if your case is terminated, if your benefits are terminated, And generally, it's frankly, more often than not, it's because Social Security says they sent a form to somebody that they never got, which of course, 9 times out of 10, it's Social Security, it's not the person. But what you can do in a situation like that is appeal it and document that the termination was improper. And you basically just have to come up with the facts to document that they didn't medically improve. And it's part of Social Security and ERISA cases have something in common, which is that you have to exhaust your administrative remedies. So if a termination happens at any point, if the person has already been approved for either ERISA long-term disability or Social Security disability benefits, you have to go through the exhaustion process where you have to show, first of all, in ERISA cases, you're entitled to the entire administrative record. So the minute you get that termination notice, and as we always laugh in my office, we see more film footage of surveillance that's done on people than, Steven Spielberg does. Because what happens is they follow people around and they don't document that they're only following them for 15 minutes on day one and they've been parked outside the house for 2 weeks. So you are entitled to that, all of the information that becomes available in the administrative record after that termination. And before that termination, you're entitled to the entire administrative record. And then you appeal it to document that their behavior was based on arbitrary and capricious conduct, which is a legal term. I go through it quite a bit in the PowerPoint. And in Social Security, it's essentially the same thing. What you want to document is that the basis on which the appeal was rendered was mistaken and for the reasons why. And you have usually in both cases, you have the physicians argue why it was an improper decision.
Understood. That's so helpful. And Mike, I'm assuming that would be the same advice that would go to someone who is in the case of a guardian or conservatorship representing another. Is that the same advice as well?
I hate to say I have some background noise. I couldn't hear all of that, but hey, Barbara knows what she's doing. If she said it, yeah, I agree.
Fantastic.
Thanks, Mike. I don't know if that's always true, but thank you.
Awesome. Well, again, Barbara, Mike, thank you so much for your time. I know we went a little over, but I hope it was worthwhile for all of you for your spoons because we had so much information. Again, the PowerPoint and the resource guide will be coming out following these webinar series, so you'll have all of that available. And last but not least, as I mentioned, there are more webinars coming up in this series, so please take a look on your screen there. And if you have time availability, again, all of these webinars are recorded, so you can check them out later. We'll be continuing our Severe ME series in partnership with Bateman Horne. And last but not least, all of these webinars, these amazing partnerships and services and programs, the resources on the Bateman Horne website, the resources on the Solve ME website, this amazing resource guide for people with severe ME that we're developing as part of this webinar series. All of these resources are free and available to you on our websites, through our networks and social media channels. And that is all thanks to donors like you. Both Solve ME and Bateman Horne in our partnership, we are both nonprofit organizations. We are sustained by the kindness and generosity and support of the community. So if you enjoyed your webinar today, if this was helpful, if you would like follow-up information, we'd love to have you both as a supporter, as a donor, and as a friend. Feel free to reach out. And I just cannot emphasize enough, Barbara has offered her time that to Google her, that if anyone saw her on this webinar, she is available for additional follow-up. Again, thank you so much for that, Barbara. And Mike will able to initiate follow-up with questions through the Solve inbox, which is solvecfs@solvecfs.org. So if you have any questions, you can drop them in that. Once again, that's solvecfs@solvecfs.org, and we can pass those up along. Thank you so much for joining us today. I hope that you had as much information and helpful dialogue as I did. Again, I'm just so grateful to our panelists, and I was so touched by how the length and the depths and the breadth of the legal world and how it overlaps into the disability space. So for those of you with severe ME, for those of you who are caregivers or loved ones of severe ME, we are here to help. I'm so glad that this webinar hopefully provided some useful information. And again, check out the resource guide as it's available. Thank you all so much for joining us today. We hope you have a wonderful rest of your week, and we will be in touch shortly with future opportunities. Thank you again and have a great day.